Our High Court Judge Thokozile Masipa this morning granted the state leave to appeal Oscar Pistorius' murder acquittal. However, the High Court judge dismissed the application to appeal the sentence. Pistorius was found guilty of culpable homicide and sentenced to 5 years in prison for killing his girlfriend Reva Steenkamp on Valentine's Day last year.
In the result, in respect of the application, in terms of Section 316, Capital B, subsection 1, the following order is granted. 1. The application for leave to appeal against sentence is dismissed. 2. It is ordered that the applicant pay the cost of the respondent in opposing the application to be taxed according to the scale in civil cases of the High Court as envisaged in Section 316, Capital B, subsection 3. In respect of the application in terms of Section 319, I am satisfied that the points raised by the applicant in respect of count 1 are indeed questions of law. Accordingly, the following questions of law are reserved for the consideration of the Supreme Court of Appeal. 1. Whether the principles of dolus eventualis were correctly applied to the accepted facts and the conduct of the accused, including error in objecto. 2. Whether the court correctly conceived and applied the legal principles pertaining to circumstantial evidence and or pertaining to multiple defenses by an accused. 3. Whether the court was correct in its construction and reliance on an alternative version of the accused, and that this alternative version was reasonably possibly true. And lastly, in respect of count 4, the application is refused.
Well, yesterday, prosecutor Gerry Nel argued that the sentence imposed was shockingly inappropriate. However, Barry Rue for Pistorius said the law was correctly applied in conviction and sentencing. The National Prosecuting Authority has welcomed the High Court decision.
What has happened today is that we've been granted leave to appeal on a question of law in as far as the murder charge is concerned, which he was convicted of couple homicide. We were then also separately appealing, or at least applying for leave to appeal in respect of sentence, which was not successful. Now, so when what I said earlier was that we are happy with the outcome, but of course we have to go back and think about whether we want to petition the Supreme Court of Appeal in respect of the sentence and also in respect of count 4, which was possession of ammunition.
Well, for more insight into what has come out of proceedings, legal expert Dr. Llewellyn Kerr-Lewis joins me now from our Pretoria studios. Dr. Kerr-Lewis, good afternoon to you. Good of you to join us.
Very good afternoon to you.
Dr. Kerr-Lewis, let's just start with some clarity on how things unfolded this morning. Judge Masipa has granted the state leave to appeal the conviction, not the sentence. What does this mean?
Well, obviously it means that if the Supreme Court of Appeal in Bloemfontein at a later stage, then somewhere next year, is inclined to also find that Judge Masipa correctly found Oscar Pistorius guilty on culpable homicide, then in that case they are not entitled to interfere with her sentence. However, if the state is successful in convincing the Supreme Court of Appeal that a murder conviction should have been imposed by the court of first instance, then in that case they will set aside the conviction of culpable homicide and then obviously then impose a sentence which they deem in the interest of justice under the circumstances.
So Dr. Kerr-Lewis, then, is this first step a victory for the state?
Well, it's not necessarily the first step of victory. One must be mindful of the fact that this is the first requirement, procedural requirement, which they adhere to. It's a small step in the bigger picture. Obviously, I was from the outset convinced that the state should at least succeed with this hurdle of the process. You must remember that the Supreme Court of Appeal will only interfere with a conviction and a decision on sentencing by a presiding judge where the judge was probably wrong in her determination of the issues. Therefore, it's still a long way to go for the state, but at least they have convinced the court, and the judge actually conceded that another court might reasonably get to another conclusion on the facts in this matter.
All right, so what happens now?
What will now typically happen is, obviously, the state will now be responsible to provide the Supreme Court of Appeal with a record. Everything will be transcribed. There are certain requirements in law, the manner in which it must be bound, etc. Then it will be sent down to Bloemfontein. The judges will have the advantage then to peruse the contents of the record. They will then call for heads of argument from both counsel. That will be provided to the judges in due course, well before the time the matter is then attended to and the date set for the hearing. At some stage, when the date is set, both parties will then appear before the judges. The judges will listen to the arguments. They will obviously engage in a conversation with regard to the legal principles and issues at stake. Typically, the judges will then reserve judgment, and more or less a month or so later, one can then expect a written judgment to be handed down by the SCA.
All right, Dr. Kaluas, very briefly, what does this mean for Oscar Pistorius? Is there a possibility that he could be placed under correctional supervision until then, or does he stay in prison?
No, what will typically happen is he will stay in prison for now. Obviously, the defense, they are entitled to seek bail pending appeal. However, I do not see any benefit for them in doing so. My personal opinion on the matter is he will stay in jail pending the appeal to be attended to. Once we get to Bloemfontein, obviously depending on the decision of the judges, if by that time he's already out on ordinary correctional supervision, in other words, on house arrest, etc., then obviously the time that he already spent in jail will be taken into consideration to his advantage to reduce the sentence that the SCA might impose on a murder charge if convicted on that. However, if the judges then conclude that Masipa was correct in a verdict on culpable homicide and sentencing, obviously by that time he should be out on ordinary correctional supervision in terms of Section 276 of the Criminal Procedure Act by then.
Dr. Llewellyn Kaluas, thank you very much, live from our Pretoria studios, just giving us insight into the outcome of Judge Masipa's ruling.